I want to again lay a foundation to make sure that we're all on the same page about the legal system in the United States. So it is a constitutionally based legal system, right? You have Article 1 that creates the legislative branch, and we know that the legislative branch was created first because the founding fathers of the United States were just coming from under the tyranny of King George, and so they did not want one individual to have all of the power. But that legislative branch, when we're talking about treaties, is really important, right? Because they actually ratify the treaties. Then we come to Article 2, the executive branch. They create federal regulations. So if you think about the legislative branch that creates statutes, they ratify treaties, they're the ones who actually create the law of the land. That has to go through a process before it gets signed into law. Then it goes to the executive branch, who's usually the final signatory when it comes to something like a statute. When it comes to treaties, though, it's flipped a little bit, because the executive goes out, they negotiate, and they sign the treaties, and then they send it to the legislative branch for approval. And we'll go through more specifics of the ratification process here in a minute. But let's talk about what the executive branch really has authority to do. They have that authority to sign and negotiate treaties. They also have the authority to present it to the legislative branch for ratification. So what does that mean? That means that the United States might be a signatory on a particular treaty, but the executive does not have to send it for ratification through the legislature. We'll talk about what that means here in a minute. But if you think about just the name executive branch, what do? They execute the law, right? If the legislative branch creates the general law, the executive branch carries it out. And so that's why under the executive branch you have agencies that create regulations. So if you think about the relationship between statutes and regulations, your statutes are the general law. For example, let's talk about the Social Security statute. So it's a general statute that says, hey, we want all working people, with a few exceptions, to pay into this fund, so when you reach a certain age, you can get money back. That's great. But how's it actually going to get done? And that's when the executive branch comes in, and that the statute actually created an agency. The agency still falls under the executive, though, because how do you actually execute that statute? How do you get the money from people's paychecks? How do you know how much someone has actually put in? How do you figure out how much money a person actually gets paid out? That's what the executive branch and the executive agencies do. They execute those general laws. They create some type of procedure to actually carry it out. Also, that executive branch has got to, if they become ratified, they've got to actually make sure the treaties are being followed through the State Department. All of those protocols, rules, regulations, sanctions, all of that is in place, up to date, and enforce within our jurisdiction. But we can't leave out Article 3, and that's our judicial branch, right? That's case law. The judicial branch in the United States actually has the power to, if they want to, look at international law, even if it has not been ratified by the United States, and actually implement it into United States cases. They can interpret treaties, and this is important when we talk about Indian law or Indian treaties later, that interpretation happens. And then, of course, we have our state and local systems. We talk about this constitutional creation of the U.S. government. We have got to think about where treaty power comes from. It also comes from the Constitution. So Article 4 of the U.S. Constitution says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." So this last part is usually what trips people up when we talk about a constitutional government in the United States. There is this concept of federalism, where the United States as a whole, or the federal government, has its policies that it's trying to create through its statutes, through its executive branch, but you have the states that want to do their own thing. My favorite current example is medical marijuana and marijuana for recreational uses. It's still at the federal level a crime to traffic marijuana, but at the states have not accepted that, and individual states have passed marijuana for various uses, medical, recreational. And so there you have that concept of federalism in play. The states saying, no, that's under our purview, and the federal government saying another thing. And so that's that struggle between federalism and a constitutionally constructed government. So you're going to see this visual again later with this section filled in, but I want to get us again to a foundation. So this is the legal structure of the United States, created by the Constitution, which created the federal law. The federal law is overarching over state and local law. And we have this dotted line to international law, because the United States doesn't really have to implement any international law. And if we think about policies of the United States in the past, the United States is always at the table negotiating treaties, always demanding this, always demanding that, and actually might be a signatory. But it doesn't mean that the United States actually ratified that treaty within United States law. So think about that for a moment, that the United States has this very strong relationship with the international community, usually sitting at the table, will negotiate hard, will actually become a signatory, but will not implement it into federal law. That's a big thing, and that shows you the power that the executive branch and the legislative branch have over what international law actually becomes domestic law. For other nations, they're thinking about the foreign power that has all of this influence on international law. So think about that for a moment. And like I said, you'll see this graphic later today and tomorrow as well, with filled out a little bit more. But that's a concept I think not a lot of people really think about, because we're always at the UN, we're always part of these talks, but how it actually gets put into our domestic law is questionable. And that's my own look at history. So let's talk about the ratification process in the United States. Like I've said before, the executive branch initiates, negotiates, and signs treaties, right? But then an additional process of the executive sending it to the Senate, who must then approve any treaty, any international document by 2/3 vote of the Senate, right? And then after approval, the president ratifies it with his signature. So the signature of the executive has to happen twice. Right after negotiation to finalize the actual agreement, they have to submit it to the Senate in particular, not just Congress generally, but the Senate in particular, to get a vote. And then it still has got to go back to the president for ratification. So basically it's going through a form of legislative process that's very similar to the legislative process for federal statutes, right? So, for instance, a federal statute, a bill regarding a particular situation, let's go back to Schoolhouse Rock and use railroad crossings and school buses stopping at every railroad. So if that becomes an issue, a bill can be introduced by either the Senate or the House of Representatives, go through that particular body. So if it's introduced in the House of Representatives, it goes through committees, it gets voted on, and once it passes the House of Representatives, it goes to the Senate to go through that process again. If there are any differences between the language of the bill passed in the House of Representatives and the Senate, then they have committee that comes together, and then they get another vote, and the final language of the bill then goes to the president for signing. Very quickly, how a bill becomes law. This process is very similar to that, right? Except the origin of the law comes from the international arena, right? And at the end, after signing, the president does a presidential proclamation of all treaties as the law of the land. So what's the power of a treaty? Once it goes through this process, a treaty is equivalent to a statute, a federal statute in the United States. And that's why I talk about the similarities between the processes. Now, they're not exactly the same, but they are similar. And the effect is that a treaty is just like a federal statute. This is what you need to know, since treaties equal statutes in the United States. They have the same legal binding effect, so they can supersede earlier statutes. So if there's federal laws in place, say, this again is just an example I'm pulling out of the air. If we had a law in our books about children between the ages of 7 and 9 are eligible to work for $1 a day on our books, and then the United States became a part of a treaty that outlawed that, then that treaty language, once it was ratified, would supersede that old statute, and that old statute would no longer be in effect. And statutes can abrogate earlier treaties. If later, let's say 10 years have passed, and the United States is losing a lot of money not having those 7-year-olds working for $1 a day, we are going to pass another statute to put it back in place. That new statute can replace that older treaty, and then you have either a suspension or a withdrawal, perhaps a termination of that treaty, right? That the executive then has to go and let the other parties know that they're no longer a part of it. And there's an amendment process, so we might generally be part of a great treaty, but maybe it doesn't go far enough for us, and we want to add additional definitions, maybe expand the coverage. So the fact that a treaty is equivalent to a statute means that once it's in domestic law, a lot of things can happen to that treaty, just like changes can happen to federal statutes. So I'm going to talk a little bit about treaty research, but seriously, this is not going to be in depth because that is a later session. But I want you to think about these things, particularly as we start talking about Indian treaties here in a minute. So usually when you're doing treaty research, you are trying to determine, right, whether or not a treaty exists, whether it's currently in force, for what parties, with what limitations, are there any RUDs attached, right, and what the topics of the treaties are. Then you also want to look at interpretation of those treaties, right? Was there any court or other body that has actually interpreted the language of that treaty and how it's been applied? Verifying and updating the status, right? You have some considerations for locating text, right? Do you need the current text for your research, or are you looking for previous versions? So what you actually need might not be what's currently in force. You might need a previous version. right? Or a draft, or maybe a pre-amendment, depending on what type of research you're doing. So the big part of this, usually though, you're looking for treaties that are enforced. There is something in the United States when you're talking about treaties called the Treaties in Force, and it's a finding aid for all ratified U.S. treaties. It's arranged in a couple of sections. You have bilateral, you have multilateral sections. It's published annually. It has indexes. It's available electronically. There's a link to look at it. Let me just say that you will not find one Indian treaty in the Treaties in Force. Consider that as we move forward with the presentation. All of the treaties in force are with foreign nations. Yeah, see, I'm already getting people riled. I had to wake you up somehow. So the other place you can usually find treaties is in the statutes at large. Okay. So if you think about, very briefly, let's talk about statutes. So we've already talked about how laws get passed. So laws get passed, they go through Congress, they get signed. Each bill that becomes a law, it becomes a public law. Public law means that it's generally applicable to all people. Let me say this at this point. Indian law statutes, which really only affect those federally recognized tribes and entities, are also considered to be public laws, just like veterans' laws are considered to be public laws. They're generally applicable. So they get passed by session in chronological order. And so the thing we have to think about when you think about laws in chronological order, it's a snapshot of what the law is at that particular time. It's not talking about the language of what it was before. It's what it is right now in this moment. So there is, the United States Government Printing Office does still maintain the statutes at large, which basically is a collection of laws as they were passed chronologically. So you know exactly at that time period what the language of that particular statute was, but only for those laws that have changed. So treaties are actually available in the statutes at large, which makes sense, right? Because they're statutes. They have the equivalent power of a statute, so they're there. So how do you find your statutes at large citation? You can get it from a secondary source, law review article. You might see a press release from the United States. You can even Google it. Yes, I do teach you Google in my research classes, but I teach you how to use it wisely. And then FedSys, or the federal government's website that has this. This is all just laying context for how you gain access to treaties in force in the United States. Because when we start talking about Indian treaties, it becomes a little different, right? Because already there is something out there that is constantly maintained that does not have any Indian treaties in it. And I said, don't forget Google. Google is very important because if you're talking about a United Nations document, you can find the title, document number, you can find treaties themselves. Be careful though, make sure you're looking at the version that you need. You can find other agreements and protocols, other learned papers, in other words, white papers regarding maybe the creation of that treaty, the negotiation, the after effects of those treaties, and other authoritative websites. That's a lot of information out there for international treaties. So one of the things that having something named like this, treaties in force, it sounds like this is the ultimate place to find all treaties in force that the United States is a party to. Keep that in mind as we move forward. Other parts of the U.S. treaty research process, you must locate the intent through background documents, right? You have some legislative texts, particularly if we're doing changes at the statutory level. You can obtain status and ratification information, right? When it actually went through the Senate for its 2/3 vote. You can see a declaration or a proclamation from the president about the effect, why the the United States was a signatory and then ratified it into law. Now here's the thing. This becomes very important because when these treaties go through the ratification process through the Senate at that time can actually only bring into force parts of the treaty. It does not have to take it as a whole because it is now domestic law. So you see, we're already getting outside of some of those big, larger processes that are involved at the international level, that once it gets into domestic law, there's some more changes that can happen. So even though you see a signatory on a treaty at a higher level, you need to know whether or not it's in effect, right? Whether it's been ratified, and whether there might have been some changes in actual implementation within the domestic law for a particular nation. So what started out as so wonderful and straightforward, even with other nations, is already starting to get muddied a little bit, right? Which is significant, particularly when we start talking about Indian treaties. And you have official sources of international treaties. Very nice. I'm not going to get into that. It was just put in here as a reminder that there are things called official sources for most treaties, and multiple ones too, multiple access points. There are congressional documents that capture the president's method of transmitting a treaty to Congress for advice and consent. There are formally Senate executive documents, well, until the 97th Congress, but now you can find it in the legislative history. And the treaty text is usually annotated, it's annexed. It's wonderful documents. For those of you that have dealt with Indian treaties, do you know of any resource that does all of those things for all Indian treaties? That's what I thought. There's another executive report series specifically that you can see the recommendation from different parts of the executive branch, from the Senate Foreign Relations Committee, the full Senate. Those committee reports are really important because you have communiques from the executive to the Senate, maybe talking about negotiations, maybe letters to help inform their voting process. And here are some treaty sources very generally, and you can find all international treaties at these sources. And so when you think about treaty status, you need to determine the following. I've already said some of this before, but you need to make sure you know at least one party to the agreement, right, so that you can find it. The conclusion, if the treaty has ended, and the entry into the enforced date, right? I put forced date there because I was thinking about the Treaty of Versailles, that Germany was forced to do some things by particular dates. So think about your RUDs, implementation, if there's any judicial interpretation, have there been any disputes? Usually if you're doing treaty research, you're looking at some type of dispute that has arisen from the treaty. Again, a reminder, you can go to the Department of State, who has a website dedicated to the treaties in force. More information, right? Because they're statutes, you can find them in the official United States Code. You can find any regulations related to the execution of that treaty in the Code of Federal Regulations. You can find any changes to those regulations in the Federal Register, all above board. And all the Federal Register is it shows you any changes in regulations from different agencies. Here's a proposed rule, we want feedback. Here's the final rule. Here are the hearings that we're going to go through talking about any changes to rules. That's all the Federal Register is. But you have a lot of information in easily identifiable sources to do very in-depth treaty research. But I'm not talking about Indian law treaties yet. I present this information to you because it's very important when we start talking about research with Indian treaties about what we don't have. when it comes to the end, when you're finding treaties, you need to consider who the parties are, whether it's bilateral or multilateral. Notice I'm repeating these things because these are the important things, and I've said them more than once, so hopefully you'll remember them. Official sources versus unofficial sources. Is this the official source for the treaty that's in force? Is this the language that's currently effective? Is it just an annotated version of a treaty by a scholar? Makes a big difference. The authenticity of the treaty that you're looking at. We've already talked about secondary and primary editions. The date of signing is usually important, and the effective dates. When was it actually ratified? Because those are two different dates. Let's look. So I pulled this one out because the Treaty of Guadalupe Hidalgo is not considered in most, actually in no collection of Indian law treaties have I ever found the Treaty of Guadalupe Hidalgo, because it doesn't specifically mention any tribes. So outside of Indian law, you would never know that this is primary, particularly to the pueblos of New Mexico. So I heard it mentioned earlier, so I'm glad we're on the same page. So let's look at this 1848 treaty. Notice everything that I've talked about, the examples that I've given have been within the 1900s. So for this one, I pushed back a little bit and went to 1848 because I thought it would be relevant to this group. So again, this is from the Statutes at Large. So you will notice on the side here, what's great about the Statutes at Large is it's an official source, one, and two, they pull out annotations for you. So you can look at these margin notes and very quickly find what you need, like what particular sections are about. So this treaty was with Mexico in 1848. It's a treaty of peace, friendship, limits, and settlement between the United States of America and the United Mexican States, concluded at Guadalupe Hidalgo, February 2nd, 1848. Ratification advised by Senate with amendments. So it was put in, but there were some amendments made. Ratified by the president, and then ratifications exchanged in May 30th of 1848, and then the proclamation came in July 4th, 1848. So if you look at the time between when that process actually stopped to when it was actually put into place, that was a series of months. That's actually pretty quick. But the process to get to this final agreement took a lot longer. You'll see it starts out in the name of Almighty God, and you'll see your margin note here is the contracting parties, so you know who is involved in this particular treaty, who the actual negotiators are, right? And here we have the President of the United States has appointed Nicholas P. Trist, a citizen of the United States, and the President of the Mexican Republic has appointed Don Luis Gonzaga Cuevas, Don Bernardo Culto, and Don Miguel Astristain, citizens of said republic. So you know who actually negotiated this. So the presidents were not actually involved. They sent a team. Looking at the first couple of articles, you see that the first Article 1 is about firm and universal peace, right? This is the primary reason for this treaty. Article 2 is the suspension of hostilities, right? There goes into some specifics here. We're now in Article 3. We're talking about blockades, troop withdrawals, houses and housing that might need to be constructed. This is the one part that is very important. This is Article 8. Mexicans now established in territories previously belonging to Mexico and which remain for the future within the limits of the United States as defined by the present treaty shall be free to continue where they now reside or to remove at any time to the Mexican Republic, retaining the property which they possess in said territories or disposing thereof and removing the proceeds wherever they please without their being subject on this account to any contribution, tax, or charge whatever. Those who shall prefer to remain in the said territories may either retain the title and rights of Mexican citizens or acquire those of citizens of the United States, but they shall be under the obligation to make their election within 1 year from the date of exchange. It goes on. This article is what protects the Pueblos from the United States government, because at the time, each of the Pueblos were considered Mexican citizens, and so their territories were considered their property, and so in the exchange, they got the right to keep their properties. Here is a screenshot of the original treaty. The left side is in English and the right side is in Spanish. And you'll note that, particularly when we talk about Indian treaties, most of the treaties look like this in this very script. And so having really wonderful digitized copies is key, because many of them have not been completely put into regular text. So now we're getting to the good stuff. Indian nations and treaties, Indian treaties in the United States. You saw part of this optic before, but you only saw it created by the U.S. Constitution, which created federal law. But in this context, we're talking about federal Indian law. There's a relationship between the federal government and tribes, or tribal law. We have to remember that even though the United States federal government was created by the Constitution, that tribes themselves are extra constitutional. That means when the founding fathers created the United States, they really didn't expect the tribal peoples that were here, women, men that didn't own property, to have any rights. The tribes were excluded really by the Constitution. That's another clause too, but you've got to know this because this comes into play when we start talking about treaties as well. So there's a direct connection between federal law and tribal law, and I'll get into explaining that in a moment. And of course, federal law relates directly to state and local law. We've already talked about that concept of federalism, that the United States creates the federal law. The states have to be accepted to be a part of the United States, and they're supposed to abide by the federal law, but there is constant struggle there. At this point, though, we also have to talk about the relationships between states and tribes, right? Because anything that happens with tribes usually has some effect within the state of which tribal land exists, where tribal people live. And it's a back and forth, because things that happen in the state affect tribal peoples. Things that affect tribal peoples usually will affect the state. But this all has to be done under the watchful eye of the federal government. And I'm going to give you like a 10-minute primer on the Indian law after this, explaining this and why this is so important in a minute. And then those darn dashed lines come back, right? And I talked about this dashed line, the relationship between the United States federal law and international law. United States has a lot of influence on international law and how it's created. But I have to say that the federally recognized tribes and governmental entities in the United States have a lot of influence on international law. No other tribal peoples in the world have the same amount of sovereignty as the tribal peoples do here in the United States. The only peoples that come close to it, I would say, are the peoples in New Zealand, the Maori, with the Treaty of Waitangi. But even then, it's not the same. So what our tribal peoples do here in the United States have a lot of effect on international law, and I'll talk about that effect here in a minute. But you can see that just by adding tribal law in there, we start getting a tangle of laws, a tangle of jurisdictions. So I did mention that tribes are extra constitutional. They are extra constitutional except for the Commerce Clause. And this is Article 1, Section 8, Clause 3 of the Constitution. It says, to regulate commerce with foreign nations among the several states and within the Indian tribes. And this is what gives the Congress authority to regulate commerce. This comes into play when we start talking about more Indian law concepts today. So before we go into an overview of Indian law, let's refresh what we learned in part 1. We're thinking about United States and treaties, right? Who the parties are, what the topics are, when does it go into effect, when can it be changed, where are we talking about, what is the exchange in land, is there an exchange, is it an exchange in land for goods, what is it, and why is that particular treaty going into effect. Knowing what we know about regular treaties, what are the implications of the existence of treaties between the United States and the indigenous peoples of North America? If we think about that, who, what, when, where, and why. The first thing I'm going to say is that the United States considered originally the tribal peoples as independent sovereigns, right? Because if we think about who has the power to go into treaties in the international arena, it's between sovereigns. So that's the first part. What are the topics? Usually they're the same. We're going to go a little bit more into this, but this is a general overview. Usually the end of hostilities. A lot of the where is in there, exchange of lands and resources, when, what are the exact time limits, if any, and why they're doing it and who benefits. So we'll talk about those things. Let's talk about the who that you learned about in the first part. So, like I said, the parties, so when we're talking about international law, we're usually talking about countries or maybe an NGO or an IGO. There's some type of sovereign entity usually that has the power to do it. So if we're thinking about sovereignty in the terms of Indian nations, it's a nation-to-nation dealing between national governments and indigenous nations, right? This can happen. That each has the power to do this. But we have to question when it comes to Indian treaties, and again, we'll dive into this more, but I want to get you thinking about it in this session today. Which of the parties does the treaty benefit if ratified? Think about that. One of the things that I put here is mainly the interactions between tribe and anyone else, if ratified into U.S. law, really benefits the federal government if you look at it. Treaties in the context of federal Indian law are usually with a guarantee of land, services, and hunting and fishing rights. Okay, this is very general overview, laying the foundation for a later session. The what and where, really for most treaties, Indian treaties, we're talking about where. It was usually involving some type of exchange in land, usually territorial transfers, land for land, right? We know that you're occupying this land. We want to occupy another land, and we'll talk about the term involving that, removal, reservations here in a minute, land for goods, land for services. So what constitutes a breach when it comes to an Indian treaty? These are just things that I want you to think about. Who has defined what that breach is? What happens when a breach occurs? What are the stipulations that happens? Are there any sanctions that are involved in these treaties? Because we know what a good treaty is, right, up to this point, when dealing with, we'll just say European nations, but other nations outside of indigenous people. We have to understand that, yes, a lot of other treaties affect different jurisdictions. New jurisdictions are created. But when it comes to Indian law, jurisdictions, remember, generally can be land and people. Any of these treaties really affect these specific people in a different way. So again, more on what? Well, what language is used? Who are the interpreters, right? Are those concepts, are these legal concepts in this formal document transferable in understanding from one language to another? What happens, we looked at the history a little bit of international law and the customary law for these long time interactions between sovereigns. What happens if a new sovereign comes into play that is unfamiliar with those interactions and those customs? They're coming from a different nation, a different history, a different culture. The meaning of property might be different, right? So I'm laying these things out, and I know people are getting riled up, and we'll get to that in the question and answers. But you've got to think about these things, because when I talked about the international concepts, it was easy to understand. Well, sure, Spain has been dealing with Britain for a long time. They've been interacting with Germany for a long time. But when you think about Indian treaties and the concept of even putting this out there, the old world, those old nationhoods, those old state mechanisms that had been interacting with each other for a long period of time, and the new world that does not have the same history, and putting an artificial construct of a state over a different type of nation, it brings a lot of questions. When? So we do have to think about when these things go into effect. And this is really important, and we'll get into more of the when in the historical context tomorrow, because it's very, very important when you think about Indian treaties. When does the treaty end? Who decides that, right? When can it be changed? Who has the power to change it? Do tribes really have the power to change it? When can withdrawals happen? And what happens if the withdrawal does happen to one party or another? Why is the treaty going into place? What's the purpose of it? And again, this is why that historical context, which we're going to go over tomorrow, really helps us inform why treaties were written, how they were written, and what the end results of them were. So I have to back up a little bit, because I have already switched into the United States and we're talking about federal Indian law. But I did mention that there is a connection between our Indigenous people here in the United States and others. And I have already talked a little bit about research. Here's one thing that I want you to remember, because in the U.S. context, we are so used to using a multitude of terms depending on the time period, right? Indian, Native American, American Indian, United States terms, right? Native people, tribal people. But once we get out of the United States, the term Aboriginal comes into play, particularly in Australia. We always have to remember to think about what the Indigenous group's current name is, what they call themselves. Santo Domingo is one of my favorite examples, because they could be Kiwa at any moment, right? What is the name that is used in that particular document? If you're going to Canada, you're going to talk about First Nations. The term used in the international arena when you're talking about treaties with Indigenous people, though, is Indigenous. But any of these other terms can go in there too, but most people at this point are using Indigenous. And I think one of the issues is that we as scholars, we haven't really agreed on what we're going to use, and really depends on the time period and the historical context, right? One of my favorite examples to use when doing any type of research is I love to put Navajo on the board. How many different ways can you spell Navajo? With an E, without an E, with an H, with a J? Could it be Dene? How do you spell Dene, right? Is it with an H? Is it with an E? There's so many different ways that you can do that. So when you're doing your research to be comprehensive, you really have to think about these things. I also want to pull this in to give everyone in the room something to anchor them, because I know I've been talking about a lot of big concepts. But if you anchor what we've been talking about to something that we all know and all do, which is research, that context starts really falling into place. So, yeah, sure.
It seems now like a lot of the pueblos were named because of the conquistadors when they came through. Now, some of the tribes have reverted back to their original name, like Kiwa.
Mm-hmm. Okay, Owinga.
Now, but I'm from Laguna, and we were discussing that. But there's so many legal documents where Pueblo Laguna is used that it would just be confusing if we were to go back to that original name.
So it can be done, but you, as the Indigenous people, need to make that determination and tell everyone that as of this date, moving forward, all of the documents that include that is us, but we are also known as and prefer to be known as this.
So you just add AKA.
Mm-hmm. You can do that, but also make sure that you are in contact with, and I know this sounds messed up, but the Bureau of Indian Affairs, because they have that list of federally recognized tribes and entities. And so you want to make sure that your name, that all of your names are there, the ones on the old documents and what you're currently known as. Because that's how researchers, that's how attorneys, that's how the legislature will be looking for your documents. They usually go off of that list. So you want to make sure that it's listed there. Oh, and the census too. We can talk about the census. It's never going to catch up to what it needs to be. And at this point, the last that I heard about the census is that when they are counting tribal people, so if I were Sioux and I would just say, or actually let me use my tribe, let's say I was Pueblo and I put Pueblo of Taos. Well, is it Pueblo of Taos or is it Taos Pueblo? Is it Tiwa? How is a governmental entity going to recognize who I'm affiliated with? Because if they don't recognize it, I won't be counted. And that means that any benefits that my people get will be down by one. But that's for another session. There are other things about the counting in this particular census that are a concern. What are the topics of Indian treaties, right? Peace, of course, land exchanges, removal, restrictions on the federal government, the restrictions on states, the restrictions on individuals dealing with tribes, sometimes restrictions, well, most of the time, restrictions on tribal people of where they can and cannot go, where they can and cannot hunt or fish, right? And again, these rights guaranteed to tribes, land services, hunting and fishing, and an overall fiduciary duty. New term, I'm going to get to it in a moment. Or actually, no, I'm going to get to it tomorrow, because if I gave it to you today, I think all of your brain matter might start oozing out of your ears. Because it really is a lot, and I thought about getting into it today. I was like, that's a lot. So let's look at a couple of different treaties. So this is an 1851 treaty for Fort Laramie. There is another treaty and that's the one that people usually talk about. I do have that one up here too. This is basically setting us up for tomorrow. And I wanted to really spend time answering more questions and pulling together these concepts at the end of this presentation, because it is very dense. And I want to give us time to unpack it together. So the 1851 Treaty of Fort Laramie. So again, remember, I'm looking at U.S. annotated documents, which happen to be the official source for the United States. So we see it's the Treaty of Fort Laramie with the Sioux, etc. in 1851. We see that it was signed on September 17th, 1851. We can find it in the Statutes at Large. Remember, that's that chronological compilation of laws as they are passed. We can see that Article 1 is about peace to be observed. But if we look at all of the people that are involved here, we have the United States government, we have states. New Mexico is involved in here, the Sioux, the Dakotas, Cheyennes, Arapahoes, it goes on and on. So here we have some good things. Roads may be established, so we're looking at the federal government and probably these local entities as well want to make roads into Indian land, right? So that's what part of this treaty is. Here's another little section about Indians need to be protected, and you're looking at westward expansion. There are lots of interactions going on there. Now we get into some more interesting language. Depredations on whites to be satisfied. So any hostilities that happened, and if there were things that had to happen, restitution needs to be made between those Indian tribes and the white settlers that had been attacked. Then we start talking about boundaries of land, and then there's a listing of each, this is all within this particular Article 5, with each tribal group and what their territories are. I wanted to make sure I captured this footnote. This treaty, as signed, was ratified the Senate with an amendment changing the annuity in Article 7 from 50 to 10 years. So at the signing of the treaty, that particular tribe thought they were signing a treaty that ensured 50 years of payment. And then it gets to the Senate and it is reduced to 10. And so this is what I'm talking about, and this is why it's really important that we understand what treaties are in the international realm, how they're treated there, then how they're treated in the United States, and the changes that can happen, because this is really going to affect our conversation tomorrow about federal Indian policies and how they affect the languages and the results of treaty making. So we continue. We have other tribes and their lands in question. And here, and this will come up, and will come up really more in depth tomorrow, we see who was there from the Sioux, from the Crow, and there were other signatories as well, in the presence of, and we have Secretary Chambers, we have U.S. Army Colonel, we have captains, we have mounted riflemen, just a lot of military people at these signings. And then we have an interpreter, Robert Meldrum from the Crows. For the Crows, you have interpreters for each of the tribes. So let's talk about that dynamic again of sovereigns coming together and negotiating a treaty. While I'm sure all of these men were warriors, they did not come to this meeting, I bet, fully armed. And you have all of these people in their military uniforms. That creates a different dynamic at the negotiation. Do you think that these individuals understood that that treaty could be changed? That they understand the processes that I went through very quickly today? So we start talking about sovereigns and trusting and customary law and protocols. We have to question what comes into play within these treaties. And believe me, tomorrow will be even heavier. But we have to start thinking about these things. So now we know what they are considered to be outside of Indian law, outside of the United States. So let's start talking about that change and the benefits and who is affected. The 1868 treaty, we have now a treaty with the Sioux, the Oglala, a number of Indian nations. So we have April 29th, 1968 is when it was signed. We see when it was ratified. So now let's look at the difference between ratification of when something was actually passed and when it was actually ratified. Remember, we looked at the Treaty of Guadalupe Hidalgo, and that was pretty quick, right? It was only a couple of months. Now we have, it took from February, so it was actually signed in April 29th, 1968. It took 10 months for it to get ratified. There are other things going on in the United States at the time. Again, this is peacekeeping and the offenders against the Indians to be arrested. So we are starting off with some good things because we've got some hostilities that are in place. But now we're back to some old language that we saw. Wrongdoers against the whites to be punished. Damages, what the damages are, how they're going to be punished. Now we have a term in here, reservation boundaries. So we've noticed that in 17 years, a lot of this language has changed. Certain persons to enter, not to enter or reside therein. Limited access now. We start talking about water rights, arable lands, right? Subsistence living, buildings on the reservation for use by the federal government. So we're talking about sovereigns again, right? Who are these treaties benefiting? What is the ultimate reason for putting these treaties together? We're going to talk about this tomorrow as well. Certain Indians may receive patents for 160 acres of land. So now we're going from what generally was a community concept of land and general ownership or use by every individual to individualizing the use of land for specific individuals and their descendants. We'll talk about allotments in our next session as well. Such Indians receiving patents to become citizens of the United States. So what happens what is this in exchange for? Many times it was an exchange for this individual land, which you will never be moved off of, for your citizenship within your tribe. So you were no longer a member of your tribe. You are now a citizen of the United States with no affiliation. And we'll talk a little bit more about that tomorrow, where they were actually holding ceremonies where men give up their bows and arrows and put their hands on a till so that they could now become farmers, and women giving up maybe their shearing knives and being given needle and threads, a sewing basket, to show the change from being an Indian to being a citizen of the United States. We also start seeing education. In order to ensure the civilization of the Indians entering into this treaty, the necessity of education is admitted, especially of such terms as are or may be settled on said agricultural reservations, and they therefore pledge themselves to compel their children, male and female, between ages of 6 and 16 to attend school. And we'll get into that in the history tomorrow. But this is really setting up our discussions and understanding why such drastic changes in scope and language and that the passage of those years. Thank you all so much. I look forward to seeing you tomorrow.